Every day in the USA, people find themselves in court.
All right. Seated. Celeste.
Thank you. I'm here present the state of Ohio versus Dennis Welch Jr., case number 25 CR 206. The defendant is in court, represented by counsel. We are here today for purposes of a tentative change of plea. It is my understanding that the defendant is going to withdraw his previously entered plea of not guilty and plead guilty to count 5, sexual battery, a felony of the 3rd degree, and count 6, sexual battery, a felony of the 3rd degree, both in violation of revised code section 2907.03A5. And in regards to sentencing, the state has indicated we will be recommending prison.
All right, Mr. Watson.
Thank you, Your Honor. May it please the court, that's my understanding of this morning's hearing. I've had a chance to fully pre-try this matter with the prosecutor. I believe full discovery has been provided. Also had an opportunity to discuss this matter with my client. He has indicated that he is prepared this morning to enter a change of plea as outlined. He understands that by doing so, he will be waiving certain constitutional rights and no threats or promises have been made in order for him to do so, Your Honor.
All right, Mr. Welk, how old are you?
34,
How far did you go through school?
10th grade.
Are you a U.S. citizen?
Yes,
Are you able to read, write, and understand the English language?
yes,
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
no,
You ever been diagnosed with or treated for any mental illness?
no,
Did you get a copy of this indictment?
yes,
Been represented to me that you're going to plead guilty to counts 5 and 6, both sexual battery, both felonies of the 3rd degree, and the remaining charges will be dismissed at the time of sentencing. Is that your understanding?
yes,
Before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you some questions. If you don't understand a question or you want to talk to Mr. Watson, let me know and I'll give you more time. Do you understand that?
yes,
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
yes,
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
yes,
Are you waiving that right?
yes,
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
yes,
Are you waiving that right?
yes,
You have the right to testify at trial if you want to. Do you understand that right?
yes,
Are you waiving that right?
yes,
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
yes,
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that?
yes,
Are you waiving that right?
yes,
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you could not afford to hire a lawyer, one will be provided at no cost. Do you understand that?
yes,
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
yes,
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
yes.
Do you have any questions about any of these rights?
No, Your Honor.
Do you still want to plead guilty to these charges?
Yes,
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
yes,
Hey, Bob, come here a minute. You understand by pleading guilty to these felonies that you're voluntarily giving up your freedom for whatever period of time I sentence you to prison, to jail, or to community control?
yes,
All right, in count 5, sexual battery is a felony of the 3rd degree, and that carries a maximum prison term of 60 months and a maximum fine of $10,000. Do you understand that?
Yes.
Count 6 is also sexual battery, also a felony 3 with a 60-month maximum prison sentence and a $10,000 maximum fine. Do you understand that?
Yes.
I could give you a consecutive sentence. That means one sentence after another for the separate offenses. If I did that, you face a maximum prison term of 120 months and a maximum fine of $20,000. Do you understand that?
Yes.
Are you presently on post-release control to the parole authority?
No.
Do you understand that your felony conviction will prevent you from owning or possessing a firearm?
Yes.
Do you understand that if a prison term is imposed in this case, that when you get out, you will be on post-release control for 5 years under the parole authority?
Yes.
They will place conditions on you. If you violate the conditions, they could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes.
If that violation is a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes.
And if that were to occur, the maximum prison sentence for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
Do you understand if a prison term is imposed in this case, you are eligible for judicial release?
Yes.
You could be placed on community control for up to 5 years, but if you violated any conditions, I could send you to prison for 120 months. Do you understand that?
Yes.
Now, has anybody promised you I would be lenient on you just because you're pleading guilty?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand I don't have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes.
Have you had enough time to talk with Mr. Watson before pleading guilty today?
Yes.
Has he discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice he's given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions at this point?
No.
All right, Ms. Alessi, if the case went to trial, what would the evidence show?
The evidence would show that the defendant in this case was the stepfather of 13-year-old. And back on February 2nd of 2025, at the time in East Lake County, Ohio, the defendant would have been 33 years old. The defendant went up to the victim's bedroom where she was laying in her bed. He laid down in her bed with her and began digitally penetrating her vagina with his fingers before then pulling down her pants and vaginally penetrating her with his penis for approximately 2 minutes before abruptly stopping, apologizing, and leaving the room. Thank you.
All right, Mr. Watson, anything to add to those facts?
No, Your Honor.
All right. Mr. Welk, did you hear what Ms. Alessi said the facts would show if this case went to a trial?
Yes.
Are those facts true?
Yes.
All right, one other thing I did not inform you of, but I'll do this before I take your plea, is I want to inform you you're pleading guilty to a sexually oriented offense, and you will be classified as a Tier 3 offender. And as a result, you'll be required to register and verify information about yourself for your lifetime with in-person verification every 90 days. Do you understand that reporting requirement?
Yes.
There are also requirements for reporting if you change your address during the term, you are required to report. Do you understand that?
Yes.
The failure to register, failure to verify residence at the specified times, or the failure to provide notice of change in residence address or other required information will result in a separate criminal prosecution. Do you understand that?
Yes.
Any question about that?
No.
All right, then what is your plea to count 5, sexual battery, a felony 3?
Guilty.
What is your plea to count 6, sexual battery, a felony 3?
Guilty.
Mr. Watson?
The defendant and his attorneys have signed the written plea of guilty here in open court, and I've signed it as well. May I approach?
Mr. Welk, is this your signature on the written plea of guilty?
Yes.
Did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Yes.
Accept the written plea of guilty. Defendant was present. Mr. Watson advised of all of his rights, made a knowing, intelligent, voluntary waiver. He understands the need for the charge, the consequence of his guilty plea, and the maximum penalty. Find to be knowing, intelligent, voluntary, will accept his plea of guilty and find him guilty of count 5, sexual battery of felony 3, and count 6, sexual battery of felony 3. Refer this for a pre-sentence report and a victim impact statement. Sentencing will be June 25 at 11 a.m. Mr. Watson.
Thank you, Your Honor. May it please the court. my client, while incarcerated, while this case was pending, had access to phone privileges, to tablet privileges, and during that time period, he did have contact with the victim in this case. As such, the prosecutor filed a motion to have those privileges revoked, and this court granted that. And since then, my client has been in isolation with no contact with anybody. My client, Your Honor, today has accepted responsibility for his actions. He is extremely remorseful. I know we'll deal with all of that come sentencing, but since sentencing is a little over a month away, my client is asking the court to reconsider the fact that he is in isolation with no phone or tablet privileges whatsoever. I have made it very clear to my client that if the court were to consider this, that under no circumstances is he to have any contact at all with the victim in this matter. He has made it clear to me that he will abide by that, but there are other family members that he would like to at least have some contact with. I don't know if the court will consider allowing him back in the general population with some at least limited contact privileges. And if he violates it, well, I mean, he's already pled guilty and he certainly knows that's not going to go favorable at sentencing. So I'm asking the court to consider or reconsider the fact that it withdrew everything and allow him at least some limited privileges. Thank you, Your Honor.
Slushy.
Thank you, Your Honor. Having phone privileges in the jail is a privilege. It is not a right, and the defendant abused that privilege. He was not only contacting the mother of the victim in this case, but using the mother as a way to get in touch with the victim, to speak with her in regards to this case. As I had indicated on the record and a little bit in chambers, the victim is 13 years old. The mother doesn't appear to be protecting her from this, further exposing her to potential psychological harm. As indicated in my previously filed motion, the defendant was not only using his PIN to contact the victim's mother, but she was also using other inmates' PINs. And it's my understanding that inmates are explicitly told that that is not permissible. So we would be opposed to him having any phone privileges reinstated. As a result of that, he was put into isolation. That was not requested by the state or our intention. That was something that the sheriff's office or the jail had done themselves. But it's in regards to phone privileges, we would still be opposed.
Well, the problem with these phones and tablets is not only were you using other people's pins, but after your privileges were revoked, they were using your pin. So this is common practice. I didn't place you in isolation. Okay. The way to control the unauthorized use of the phone or tablet is to place the inmate in isolation. So that's why you were placed there. So as Ms. Alessi said, you've abused the privilege that you had and you're not going to get it back from me. Anything else?
We would ask that bond remain revoked, Your Honor.
Because
All right.
seated.
Thank you, Your Honor. We are present in the state of Ohio versus Dennis Welk in case number 25 CR 206. The defendant is in court represented by counsel. We were last here on May 14th where the defendant pled guilty to count 5 and count 6, both being sexual battery felonies of the 3rd degree. At that time, the court referred the defendant for a pre-sentence report and victim impact statement. Those reports have been completed and the state is prepared to proceed with sentencing.
Mr. Watson.
Thank you, Your Honor. May it please the court. I'm going to be brief. This was a heinous crime, Judge. This was horrible in a lot of ways, but most importantly, because this was a minor child who almost assuredly didn't fully understand what was going on with somebody whom was entrusted to love her and to protect her. However, Your Honor, this is not indicative of who Mr. Welk is as a person. Yes, he has a record Yes, he has been to prison, but it's mainly in the past been for drug offenses, I believe some theft offenses, nothing of this magnitude. On this day, and this is not an excuse, Judge, for his behavior, but on this day, Mr. Welk was drinking a lot, was highly intoxicated, and took advantage of his stepdaughter. He, since the day I met him, he is in disbelief that he did this. He has expressed to me his remorse and his sadness and how he hurt her, how he hurt his wife, how he hurt the rest of his family. He knows, Your Honor, that he's going to be spending a lot of time in jail coming up. I know there's discretion with the plea with how much time that equates to. This court has a lot of discretion with that. Earlier in chambers, the state and I presented to the court a joint recommendation for 8 years. I'm going to respectfully ask the court to consider imposing that sentence because I believe Mr. Welk is remorseful. I believe that this is not who he is as a person. And I'm hoping when his time is up and he gets out, which, by the way, he's going to be reporting as a sex offender for the rest of his life. So he's going to be under a microscope. He's going to be monitored for the rest of his life. But I'm hoping that he'll be able to piece things together, make amends with at least part of his family. I don't know if he can ever make full amends with everybody or not. And you're going to hear from him in just a minute, Your Honor. But again, I don't think this is who he is as a person. And I'm going to respectfully ask the court to consider adopting the joint recommendation. Thank you, Your Honor.
All right, before I hear from Mr. Welk, I'm going to read the explanation of duties to register as a sex offender and ask for him to sign it, acknowledging that he was informed of these terms. This is Lake County case number 25 CR 206, 2 counts under 2907.03 subsection A5. Dennis V. Welk Jr., 35461 Lakeshore Boulevard in Eastlake. You've been convicted of or pleaded guilty to a sexually oriented offense and or child victim offense as defined in 2950.01, and you are a Tier 3 sex offender / child victim offender registrant. You are required to register in person with the sheriff of the county in which you establish a residency within 3 days of coming into that county, or if temporarily domiciled for more than 3 days. You are also required to register in person with the sheriff of the county in which you establish a place of education immediately upon coming into that county. If you establish a place of education in another state but maintain a residence or temporary domicile here, you are also required to register in person with the sheriff or other appropriate official in that other state immediately upon coming into that state. You are also required to register in person with the sheriff of the county in which you establish a place of employment if you have been employed for more than 3 days or for an aggregate of 14 days in a calendar year. If you establish a place of employment in another state but maintain a residence or temporary domicile here, you are also required to register in person with that sheriff or other appropriate official in that other state if you have been employed for more than 3 days or for an aggregate of 14 days in a calendar year. Employment includes volunteer services. You are required to provide to the sheriff temporary lodging information, including address and length of stay, if your absence will be for 7 days or more. After the date of initial registration, you are required to periodically verify your residence address, place of employment, and or place of education in person at the county sheriff's office no earlier than 10 days prior to your verification date. If you change residence, address, place of employment, and or place of education, you shall provide written notice of that change to the sheriff with whom you have most recently registered and to the sheriff in the county in which you intend to reside, or establish a place of employment and or place of education at least 20 days prior to any change and no later than 3 days after change of employment. If the residence address change is not to a fixed address, you shall include a detailed description of the place or places you intend to stay, and no later than the end of the first business day immediately following the day you obtain a fixed address, you must register with the sheriff that fixed address. You are further advised, in accordance with federal law, you must report any international travel to your registering authority no less than 21 days prior to travel. Failure to do so may subject you to a criminal prosecution. You shall provide written notice within 3 days of any change in vehicle information, email addresses, internet identifiers, or telephone numbers registered to or used by you to the sheriff with whom you have most recently registered. You are required to comply with all the above described requirements for your lifetime with in-person verification every 90 days. Since your expected residence address as stated above is located in Lake County, you shall register in person no later than 3 days after release with the county sheriff's office at 104 East Erie Street, Painesville. Failure to register, failure to verify residence at the specified times, or failure to provide notice of change in residence address or other required information as described above will result in a criminal prosecution. Mr. Watson, if you would present this to Mr. Welk for his acknowledgement and signature. All right, Mr. Welk, what do you want to tell me before I impose sentence?
First and foremost, I'd like to apologize to the courts for appearing before them today. I'd like to apologize to the victim in this case. I'm not going to use alcohol or drugs as an excuse for anything. However, alcohol was a main factor in this case. But I take full responsibility for my actions because I chose to make the irresponsible decision consuming too much alcohol than I could handle, causing poor, regretful choices leading to my incarceration. I've read the police reports and feel ashamed, embarrassed, and hurt because that's not the person I am. And I wouldn't be standing here today if I would have just been more responsible. I have 4 younger children that I've let down because of being locked away from them, missing out on watching them grow. Having to deal with that is a heartache alone. The only thing I can do now is work on myself while incarcerated, take advantage of all programs they offer, and become a better man and a better father, and not give up doing so. I have to make this my last time in jail, and I plan to. I'm sincerely remorseful to my victim in this case, letting her down when I was supposed to be a father figure in her life. I beat myself up over this every day, wishing I could take it all back. I just hope she can grow up in life and leave this in the past, and that it doesn't affect her future. Again, I'm sorry to everyone I caused pain to in this case.
Ms. Alessi?
Thank you, Your Honor. One thing that the defendant said today in court, and even in his pre-sentence report, that stood out to me is that he was supposed to be a loving and caring father. And I couldn't agree more with that. He should have been someone that the victim could trust and rely on for protection and guidance. And instead, he used his role as a parental figure to manipulate her, exploit her, and violate her. When this happened, the victim was just 13 years old, 13 years and 8 months to be exact. And as much as the defendant wants to talk about the other children in his life, when the defendant committed this offense, it was done in his home, in her home, with his other children present. Not only that, his 4-year-old Sarah and the 7-year-old Ben actually observed the defendant engaging in the kissing and the touching of the victim's erogenous zones. Later, when the defendant went into the victim's bedroom to engage in the sexual conduct, a 1-year-old was sleeping in the pack and play next to her, and there was a 3-year-old in the room who was awake on her phone, according to the victim. And while there is a jointly recommended sentence here, the state believes it's essential to highlight not only what the defendant did pre-indictment, but also what he did after his arrest in this case. While incarcerated, he continued to communicate with the victim while in the Lake County Jail. He attempted to guilt and manipulate her by blaming her for her own suicide attempt at the East Lake Jail. He pressured her to express her feelings to law enforcement about him, or her desire for him to only receive a short sentence. He spoke of wanting to attend counseling together. He emphasized they were a team and told her he loved her, despite being her abuser, despite doing what he did here. And during several of these recorded calls, you can hear the victim crying, further illustrating just the ongoing emotional harm caused by the defendant and his conduct. This behavior demonstrates his continued disregard for the well-being of the victim, his family, and his ongoing efforts to control her and manipulate her. The defendant today in court said he's remorseful, but in the pre-sentence report, he didn't believe he did anything wrong, and he wants to take this to trial. So I'm not sure what this court can believe. He has a lengthy criminal history, including 4 prior prison numbers and 5 felony cases. And all of this, I think, supports the need for a significant term of incarceration, and respectfully ask this court to impose a jointly agreed sentence of 8 years. Thank you.
Thank you. Why did you call her after you were in jail?
Because I was told by the detective I was allowed to.
Okay.
I didn't call her. I called my wife and she answered the phone.
All right. And what contact did you have with her about retracting her statement or modifying her
It
statement?
wasn't retracting. It was we talked about counseling, going to counseling and stuff, because that was something that they was talking about making them do, and something she said she didn't want to do.
Well, trying to, whether directly contacting her or contacting her through your wife, was wholly inappropriate. And it was further evidence of you trying to take advantage of her at that young age, like you did when this happened.
Now she had asked the detective if she could have contact with me when this case was all started.
Who,
Then when
who,
I went to my preliminary hearing on February 11th, I asked the detective and he told me the same thing.
well, you're experienced enough in the system to have the wisdom that you shouldn't have been contacting her. In talking to her, having about anything having to do with this case. So you've in your statement you say you apologize to her, but then in the pre-sentence report you talk about how you don't believe you did everything you're accused of doing and wanted to take this to trial. What's that all about?
I don't remember exactly what I said, Your Honor, but what I was saying was I don't have recollection of what happened the night of, so I wasn't admitting to. I don't know what happened.
So did you or didn't you do this stuff?
Yes.
And I got to tell you, it doesn't get much worse than this kind of stuff.
I understand.
And I would note in the record that in 2009 or 2010, you were sentenced to prison on a burglary, released on judicial release, and then returned to prison after a violation of the judicial release. And you were released January 7th of 13. You went back to prison on another case on May 1st of 13 and got out in August. Went to prison on an attempted burglary, trespass in a habitation, breaking and entering, June 23 of 16 through August 5 of 18. A whole bunch of theft offenses between that last prison sentence and where you are today. So you've had a lifetime of criminal activity, but none worse than what has occurred here. I've reviewed the pre-sentence report and a victim impact statement. I've considered what you have said, what counsel has said, and I've also considered that they've made a joint recommendation of 96 months in prison. And so on count, and I've considered all the provisions in 29, 29, 11, 29, 29, 12, 13, and 14. In consideration of all that, on count 5, I'm going to sentence you to a term of 60 months. On count 6, I'm going to sentence you to a term of 60 months that will be consecutive to one another, with credit for 143 days. And consecutive sentences are necessary to protect the public from future crime by you and for appropriate punishment.
All right, get out, man. Come on, man.
Sit down.
You mean, man?
Stay down.
No, man. Get me
Yeah.
the fuck out of here, man.
Judge.
And
Took my plea back, man. Get the fuck out of here, man. Get me out of here. Get me out of here, man.
Sit down.
Get me out of here, bro, man.
Almost done, Judge.
Get the fuck out of here.
yeah, they
No, man. Get me out of here.
Stop.
Get
consecutive.
me out of here, man. What the fuck you mean, nigga?
Hey,
Get me the fuck out of here. Man, get me the fuck out of here, man. Get me out of here, man. Take me to jail. Okay, we're in the jail, man. No, we're going in the morning.
Put me on your visiting list.
All right.
We're in jail and
Fine, man. Stop touching me, man. I'm not doing that, man. I'm not doing that. I'm not doing shit.
All right, consecutive sentences are necessary to protect the public from future crime by the defendant and for appropriate punishment. And they are very proportionate to the seriousness of the conduct and the danger he poses to the public. And his history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crime by the defendant. Costs are assessed, the remaining charges are dismissed. Anything else, Ms. Alessi?
no, Your Honor, thank you.
Mr. Watson?
Nothing further, Your Honor.
All right, we're adjourned.
All right.